Thanks everyone for joining. We see people still logging in, so let's probably give everyone 30 seconds before they join and before we start this hopefully wonderful webinar for this August gathering. Perfect. All right. Thank you so much, everyone, for joining and for taking up the time in today's wonderful webinar titled Reading the May 2026 Visa Bulletin Like an Immigration Lawyer and EB-5 Expert. Not sure as an immigration lawyer, because that takes a lot of guidance and experience and years of hard work, but surely the interest of today's webinar is to educate people and empower them to have a basic understanding of the visa bulletin that is issued every month by USCIS. Before we begin, I'd like to very briefly introduce US Immigration Fund and Greenberg Traurig as the law firm, as well as our August speakers and for the day. US Immigration Fund, the company I represent, is a premier EB-5 regional center that has been there in the business of EB-5 since 2010. Over the last 15 years, we've worked with over 6,000 investors, raised about $3 billion of EB-5 capital, and look forward to continuing the good work and helping investors achieve their American dream. When we talk about Greenberg Traurig, it is an international multi-practice law firm with over 3,100 attorneys across 51 offices worldwide. I must say that is a huge number. Their firm advises clients across complex legal, regulatory, and cross-border matters through a global platform built to support businesses, investors, and institutions operating in today's legal and commercial environment. Greenberg Traurig's immigration and compliance practice brings deep experience across business, immigration, and especially the EB-5 investor visa program, which is what brings our dear guests for the day, Kate and Jennifer, on this webinar. A little bit about myself. Ladies and gentlemen, my name is Akshat Gupta. I work as Vice President of Business Development at US Immigration Fund. I head the India and UAE practice for the company and essentially is pretty involved when you look at Indian investors all across the globe, along with key markets such as GCC and Singapore as well. Without further ado, I'd like to introduce our first speaker for the day, Ms. Kate Kalmykov. She's a shareholder at Greenberg Traurig. She has over 2 decades of experience in business immigration and has a deep experience across all aspects of the EB-5 visa program. She advises regional centers, developers, investors on EB-5 structuring, compliance under the EB-5 Reform and Integrity Act, investor petitions, and immigration strategies across complex business and employment-based matters. Kate, thank you so much for joining us today. We're really grateful for your presence.
Thank you so much for having me. Jenna and I are looking forward to this.
Awesome. Our next speaker for the day is Ms. Jennifer Hermansky, again, shareholder at Greenberg Traurig. She's leading member of the firm's EB-5 practice. She focuses on employment-based immigration and brings deep experience in EB-5 structuring, investor petitions, regulatory compliance, and regional center guidance. Jennifer, again, thank you so much for joining us today.
Thank you. Thank you for having me.
Yes, and I would say above all, of the little I've known of Jennifer and Kate, they're absolutely amazing colleagues, and they're super kind people. So I'm really grateful for them, for joining us today. Let's move on and set the objective for the webinar straight. I guess our intent of doing this webinar today for all funded, to be funded, or prospective EB-5 investors and other people who are on a valid visa program in the US is as follows. This webinar is focused on helping attendees interpret the visa bulletin accurately and apply it to their own situation. We hope that by the end of this session, attendees should be able to read the visa bulletin independently and have a basic understanding of its implication for their specific case. Why this webinar? As a concept, we were inspired by the thought that every month there is a visa bulletin. People see the movement, they try and interpret it, they get conflicting answers that leads to delay in decisions, at times incorrect ones as well. A lot of people have lack of correct information and clarity on how to use the information if at all ChatGPT comes to rescue. So to help all of these investors, we've curated a special webinar for you today, and we're essentially going to be focusing on the following concepts in brief. What is the visa bulletin? How do I read the visa bulletin for my case? Understanding what is chart A, chart B, how to use it, key terms that matter. What is the May 2026 visa bulletin telling us? What is the difference between filing versus approval? Some real life case scenarios followed by close to a 20-minute section for just Q&A for this audience. So feel free to drop in your questions and we'd be more than happy to take them. Status or I-485 as a concept, very briefly covering a concept called retrogression, any common mistakes, and as I said, questions that we welcome from this audience so that we could, help you guys out. All right. So I think my first question is for you, Kate. What is the visa bulletin and why is it issued every month?
So the visa bulletin is a way for investors to monitor when they can both file their actual green card application and when they can reasonably expect that it will be reviewed. So when Congress created the employment-based categories, they created 5 categories, EB-1 through EB-5, and there's 140,000 green cards given annually, with 10,000 allocated to EB-5. Within EB-5, after the Reform and Integrity Act of 2022, we had a further breakdown of the categories to be rural, high unemployment TEA, and infrastructure. And so when you look at the visa bulletin, you can figure out when you can file, and that is something we call Chart B. What you have up here, which is the final action date, Chart A, is actually when you're allowed to determine when your application can actually be approved. So if you filed after the date indicated, you're not up for adjudication yet. If you filed before, you are. And if you see the letter C, it means that green card numbers are available in your category and there is no backlog, so no queue.
Okay, so we'll definitely cover these concepts in much greater detail as we move forward. Jennifer, coming to you, in the interest of the audience, can you very briefly help them understand what exactly is an employment-based category and what is this EB-1, 2, 3, 4, and 5 as a visa category?
Sure. So as Kate mentioned, each year we have 140,000 employment-based green cards that we give out each year. Our immigration system gives out permanent residency or green cards to the U.S. based on different types of categories. So one overarching category is family-based immigration. So where you have a family member sponsor you for a green card or permanent residence to the U.S. The second type is through employment. So where you have a U.S. employer sponsoring you for a green card to the U.S., or where you can sponsor yourself for a green card through the U.S. based on either your ability and your future employment or through an investment like EB-5. So those are the two major categories. The third minor category is through our green card lottery, where people are granted green cards from countries where we historically don't have much immigration from. So, there's not many countries have the benefit of using the green card lottery. So for purposes of this webinar, we're going to be focused on the employment-based category. So employment-based first preference is for those individuals who are able to sponsor themselves potentially because they are an alien of extraordinary ability, meaning they're at the very top of their field. You can also have an employer sponsor you for EB-1, either because you are an outstanding researcher or professor, or because you are a multinational manager or executive. So that is a very popular category where you are able to get a green card through the US because of your employment abroad, and you are then transferred to the US to work at a related company as a manager or an executive. So that's an employment sponsored category where the employer is sponsoring you. The individual is not sponsoring themselves. In EB-2, it's our second preference category. So under this category, we have people who are being sponsored by an employer potentially because they have a job for them in the US, and the job requires at least a master's degree or higher, and the individual that they are sponsoring has at least a master's degree or higher in that field. Also in EB-2 is another popular category called the National Interest Waiver. This is a category for individuals who are self-sponsoring, and they are showing what they do in their field of expertise and generally how their immigration to the United States is in the national interest of the US. So that category is quite popular, but it's also challenging to get. In the third preference, we have employers sponsoring individuals for green cards. And in this category, we have a number of different types of positions, but they're all sponsored by an employer. And depending on, the background of the individual and the requirements for the job, generally, these are professional jobs requiring at least a bachelor's degree or higher, or skilled workers that have certain skills. And other workers are also sponsored by a U.S. employer, and those are individuals who are coming to the U.S. to do specific types of jobs, and an employer is sponsoring them for it, and they don't necessarily need any specific education requirements for that. So the important takeaway, though, for EB-1, 2, 3 is that most of the categories, unless you're at the very top of your field of expertise, most of the categories are going to require a U.S. employer to sponsor you for the green card. And so what do individuals do who don't have an employer to sponsor them in the U.S., or they don't have a family member to sponsor them for a green card? Or maybe they do have those things, but there is a long wait time for those green cards. So EB-5 that we're talking about today is a really good opportunity for people because they can sponsor themselves without needing to have the employer sponsor them. So, we also have fourth preference here in religious workers. So those are, generally the fourth preference is for very specific classes of people, including religious workers. And then we have EB-5. And as Kate mentioned, we have those broken down under our unreserved category for our pre-RIA investors. And then we have our 3 set-asides for our new EB-5 investors who are filing their petitions after April 2022.
Awesome. That was really helpful. Thank you, Jennifer. Kate, coming to you, this is for the interest of the audience, the fact that there is a China, India, Mexico, or a Philippines written here, what exactly does that mean? And how is this category of country as chargeability extended by USCIS?
So Jen talked a little bit about underrepresentation in the United States and why we have the lottery, for example. Well, we want to control how much immigration as a public policy we have from each country coming to the US. So we have 140,000 green cards given annually in employment base, and we don't want any one country to dominate the issuance of green cards. We want it to be done equally. So it's always traditionally in the past been done no more than 7% to any one country. And then if the category has leftover green cards, we reallocate. So the reason you see China and India is because two countries with very large, very well-educated populations that have applied en masse in the different categories for green cards. And so a queue has developed for them to be able to actually process for the green card. They can file the preliminary step of their application, but to actually process and have a green card issue, they have to be subject to per country limitations annually. And then on October 1st of the government's fiscal year, the numbers reset, and the State Department on the Visa Bulletin, you may see a big change or shift in these numbers as the new fiscal year begins because more visa numbers become available. And Mexico and Philippines, less in EB-1 and EB-2 or EB-5, but more in the essential worker categories, EB-3, bachelor's degree, or religious workers religious workers or special immigrants have also sort of exceeded their allotment.
Sure. So if I am an Indian who is currently residing in UAE, citizen of UK, but born in India, at the end of the day, when I'm applying for EB-5, I'm going to be referring to this India chart. Is that correct? So they look at the country of birth.
That's a great question. Yes. It doesn't matter what citizenship you get later. It doesn't matter what residency you get later. It goes off your country of birth. But there is one exception, and that is who you marry. If you're Indian born, but you marry someone who was born in the UAE, you can charge your nationality to your spouse, which would take you out of any kind of backlog due to retrogression. So you can charge to your spouse's nationality, but you can never change your nationality for purposes of the Visa Bulletin.
Sounds good. Jennifer, coming back to you, can you help, again, just for the interest of the audience, what exactly is a priority date? And then let's probably start talking a little bit about the two charts that USCIS publishes for the employment-based categories every month. And probably you could cover the final action dates and we could move to Kate for the second chart.
Sure. So as you can see here, we have lots of dates on the Visa Bulletin chart. These dates are a priority date. Every person who is immigrating to the U.S., and specifically here in these employment-based categories, receives a priority date upon the filing of a certain type of application or petition. So for EB-5 purposes, when you make an investment and you file the I-526E petition to start your immigration process, the date that you file the I-526E petition with USCIS is going to be your priority date. And the priority date is found on the receipt notice that you get from USCIS when the case is filed by you. In some of these other categories, if you are sponsored by an employer in EB-2 or EB-3 or other workers, the employer may file a labor certification application to start a process for a foreign national, and the date that is filed might establish the priority date. But for our purposes here, for EB-5, we don't have a labor certification filed by an employer. We have an investor who makes a qualifying investment and then files an I-526E petition with USCIS. So that establishes our priority date. And then each month when the State Department is releasing the Visa Bulletin, they will put these dates in the Visa Bulletin. We call those the cutoff dates. So if your priority date falls before the date found in the Visa Bulletin, then the government can issue a green card for you. So as Kate mentioned, we're looking right now at chart A, the final action dates. meaning if your priority date comes before these dates, so if I'm born in mainland China and I am a fifth preference unreserved investor because I filed my EB-5 petition before the passage of the RIA. If I filed my I-526 petition before September 22nd, 2016, the government can issue me the green card based on the EB-5 approved petition. So essentially, getting the process started and filing the EB-5 petition establishes your place in any line that is developing at the government for a green card. So getting your case filed for EB-5 purposes and establishing your priority date is really important.
Perfect. Kate, let's come to you about a little bit about Chart B and how is it applicable for investors.
So Chart B is important because it shows when you're actually allowed to submit your application, which can be a 485 or the consular processing application through the National Visa Center, through the online portal, where everyone who's processing at an embassy or consulate overseas has to submit their documents for each family member.
Sure. Coming back to, just for our current investors who are looking at filing EB-5, does the term C helpful? Does that mean that they can file? How do they interpret the reserved visa categories? If we can talk about that a little bit.
Yes, it means it's current. It means that it can be approved, right? If we're looking at Chart A, it doesn't mean that we can necessarily file. So for new investors, we don't have a backlog issue. It's for pre-RIA investors. In 2022, for the first time, we got a comprehensive change to the EB-5 law since it was initially introduced in 1990 through IMACT 90, and then the Regional Center program was introduced in 1992. So they sort of divided applications that were pending before the RIA and applications after the RIA. And so anyone who's post-RIA are new investors, anyone post-2022, as you can see, if they're filing in one of the set-aside categories, they are current. And that has been a great thing for many of the investors that were subject to a backlog previously. We even had clients when the RIA was passed withdraw their pending applications that were subject to the backlog and reinvest so that they can get their green cards without any kind of wait. And, if we're talking about applicants that come from India, for example, and they have maybe an employer who sponsored them in EB-2 and EB-3, it's a very, very long wait for a green card. So the EB-5 really makes sense for a lot of them because it's the fastest way that they're going to get permanent residency for themselves and their family members.
Sure. I was just, I guess you probably are reading my mind, but I was just going to come to that. Jennifer, coming back to you, a majority of the Indian investors in the US are obviously people who are working at Google, Meta, Tesla of the world, and are looking at EB-5, obviously with EB-2 or EB-3 petition ongoing. How have those trends generally been over the last few visa bulletins? And what is it that they can take away as in terms of a direct understanding of pursuing EB-5?
Well, we see many individuals that already have another employment-based process started for them also do EB-5. So we know that there are many potential investors out there who have an EB-2 petition or an EB-3, as Kate stated, and maybe they are born in India or born in China, and they have a significant visa backlog or wait time in those categories. So we can see here that right now, an individual born in India that has an employment-based second preference petition filed for them by their employer can only now receive a green card if their petition or their employer started the process and filed either an I-140 petition or a labor certification before July 15th, 2014. And so, on its face, the backlog reads like those people are waiting 12 years, but in reality, they may have waited longer than that because we don't see the visa bulletin moving forward one day on the visa bulletin for one real day in calendar time, right? So unfortunately, the visa bulletin may languish here on or around this date for a very long time. And so even though it appears that there might be around a 12-year backlog for EB2, we know that it is probably quite more substantial than that if an individual is just now starting an EB2 process with their employer. So definitely there's a huge trend that we are seeing in the US where these individuals who are working here and living here want a second potential path to permanent residency because it might not be possible for them to ever get the green card through EB2 or EB3. And so they're looking for a way to take control of their own immigration and not have to rely on their employer or not have to wait the next 30 years in their same job in order to get a green card. They want to have upward mobility and be able to change their employers. And so we see a lot of people filing EB-5 for that reason.
Yeah. Kate, coming back to you, since the RIA, because of the eligibility of being able to file concurrently the adjustment of status file along with the IFF-260 petition, the visa bulletin has obviously been the talk of the town every single month, right? The fact that it stays current for the reserved visa category, how significant is it for those who are currently in the US who are planning to file an EB-5 visa petition along with an adjustment of status to apply for their EAD APs as well?
Well, it's a huge thing, right? If you're in the US and you file concurrently, even if there is retrogression later, and we can talk about that separately, but even if there is, you're permitted to remain in the United States. You're permitted to get employment authorization, travel authorization, and extend that employment and travel authorization even if you're retrogressed for as long as you need to be until your application is adjudicated. So that's huge, especially, we talked about people here in H-1B status. Well, some may want to change employers. It's difficult to do that as an H. It's a very expensive proposition these days to change as an H. For many, they find that they have a competitive advantage when they're interviewing and they're able to tell employers they don't require visa sponsorship. It's also a huge thing if you're a student in the US and you have an EAD. It's much easier to find employment than to find an employer who's going to hire you straight out of school and then sponsor you for an H that with legal fees and filing fees costs around 8 to 10K these days.
Sure. I completely agree. All right. So, Jennifer, coming back to you, there's obviously been a lot of confusion that people have had, specifically even those who are looking at filing EB-5 because of a scare of retrogression. Obviously, the May visa bulletin said something about the Indian category. Can you, sort of elaborate a little bit on the point E and clarify that that's more for the unreserved visa category than the current reserved visa category, at least as of what the visa bulletin says?
Yes, so this is a note found in the May 2026 visa bulletin from the State Department. They are alerting the public here that they have sufficient demand for investors born in India in the EB-5 unreserved visa categories that will make it necessary to retrogress the final action date or potentially make it unavailable. So this, very importantly, this is in the EB-5 unreserved categories. So unreserved, what does that mean? It means all of our EB-5 investors who were born in India and who filed an I-526 petition prior to March of 2022. So everyone who is a pre-RIA investor, like we've been talking about, is in that category lumped together. And then if you have filed a post RIA EB-5, but you are not in a project that's in a rural area or a high unemployment area or an infrastructure project, you also fall into the unreserved category. So in the final action date, you will see there is a cutoff date. I believe it's now May of 2022. So interestingly enough, by May of 2022, we are already having the RIA passed, right? So it looks like now all of our pre-RIA India-born investors are able to move forward with their 2-year conditional green card. And then there might be some out there, I don't really know any, but there could be an investor born in India who has invested $1,050,000 US into a project that is not in a TEA, that is not in a rural area, or that's not an infrastructure project. And if so, then you also are now experiencing this backlog as well.
Makes sense. Kate, coming to you, there's always been a mention of from the State Department of referring to a specific chart for filing the adjustment of status, and it could probably change month by month as per their discretion. So any thoughts on that, if you can share? What exactly is this, and how can I be, as an investor, mindful of referring to the right links so that I'm aware of the same?
Sure. So, I think it's very important to monitor, as I said, the visa bulletin. And if we're talking about filing and submitting your application, we're usually talking about Chart B.
All right.
And importantly here, that's actually the USCIS chart. So the State Department releases the visa bulletin each month, and the State Department is in charge of the overall monitoring of the visa numbers. However, USCIS is in charge of adjudicating green card applications for people here in the US, right? People who are interested in filing the I-485.
Yeah.
And so it's not good enough, actually, that you're current under Chart B. You also have to click on the link to follow the link to the USCIS website and see if USCIS is going to allow the Chart B filings. Because if we look actually in the May visa bulletin, we see Chart B dates. And, for example, a lot of the investors who were born in mainland China in the unreserved category move forward quite a lot to March 1st, 2017. But guess what? If you click on this, it says here above the chart, visit USCIS.gov visa bulletin info for information on whether USCIS has determined this chart can be used. So when you go and click on that link, you move forward to a USCIS website that says whether or not you can actually file an I-485 application based on the Chart B. And guess what? In May, we cannot file an I-485 based on Chart B filing dates. So unfortunately, for all of the people who moved forward in the priority dates through Chart B, we can start the visa application process for an immigrant visa if they are abroad. We can pay a fee to the State Department. We can submit an application and we can get that process going with the State Department. But USCIS says they're not yet ready to accept the I-485 filings for individuals who became current under Chart B. So each month we have to check the visa bulletin, but then also whether or not USCIS is going to allow the Chart B filings. They will always allow a Chart A filing. So if you became current under Chart A of the visa bulletin, then you are eligible to file the I-485.
Sure. Thank you. Thank you so much for that detailed answer. So we're obviously being poured with a few questions. I'm going to take the liberty to run them by you. One of our first questions is that is the selection of the category, whether it's rural or high in employment area or infrastructure, going to influence the timeline of me getting my EAD-AP card?
No,
Any thoughts on that?
unfortunately. I'll take that one. So no, the EADs and the advanced paroles, which are applications for employment authorization and a travel document, while the I-485 is pending, they are individualized applications. They are not prioritized if you go into a rural project. The priority that you receive in a rural project extends to the I-526E. It's not even clear if it really extends to the I-485, in my opinion, although sometimes we do see those going faster, but it definitely is not going to extend to the EAD-AP. You need to just review the USCIS processing times website to see the current processing time for those applications.
Sure. Kate, this is for you. We have an investor saying that I am traumatized with the data that I see on the internet. It talks about years of retrogression while I plan to fund $800,000 of my hard-earned money. And keeping in mind that I'm Indian born, is EB-5 still the fastest route for me while I'm in the US?
Yes. And, obviously we posted the visa bulletin. The only thing that would be faster is marriage to a US citizen. But absent that, EB-5 is the fastest. And that's frankly why we've seen so many filings from Indian nationals, particularly since the RIA has been passed, and particularly for those that are in the US. They may even have EB-2 or EB-3 pending, and they take advantage of the EB-5 route because it's faster for them.
Jennifer, let me ask you this. Is the priority date petition for I-526E, there's a question that came in, does it reach the lockbox in the Texas office? Is that is there a specific office, or it could probably be distributed amongst various departments or locations internally?
So each time we're filing an EB-5 petition, the I-526E, we check the filing instructions from USCIS. So right now, the EB-5 petitions are filed in paper with the Texas lockbox location. And the priority date you will see is the date that your petition actually reaches the USCIS office there in Texas. You'll see on the receipt notice, there is a priority date and then also a notice date. And there will be some difference between the two. The priority date is the date it was actually received, and the notice date is the date they get around to mailing you your I-526E receipt notice.
Sure. Kate, what are the general timelines that we're seeing for an EAD-AP approval, at least in 2026? I know those timelines were pretty optimistic, I think, if I may say so, in 2025, but I guess we'll all agree that they've slightly changed. So any thoughts on the same?
It's taking about 8 to 10 months, and sometimes even faster. And I will tell you that they split up the combo cards. I saw there was a question about combo cards. They're not issuing those right now, but the EADs are coming in faster than the advanced paroles from what we're seeing.
Yeah. And are these, just for the clarification of the audience, how long are these EAD-APs coming from? Is it a year and a half? Is it 5 years like we used to get in early 2025?
18 months.
18 months. And investors obviously need to apply for an approval or a rather renewal process for the same so that it doesn't expire.
And I would do it as early as possible. You're eligible to do it 6 months before expiration. That's what we're doing for our clients.
Sure. Jennifer, this question's for you. If I filed for an I-526C, however, my EB-5 category does get retrogressed, while I am having a valid EAD-AP, can I travel on that, or would you recommend me to, use my H-1B instead?
This is a good question. So certainly if you have filed an I-526E and you have properly filed the I-485 and that remains pending, and you have a valid EAD and advanced parole, You certainly can use the EAD to work, and you can use the advanced parole to travel if you wish. If you are on H or L status, those are the two categories of non-immigrant visas that have dual intent. So it is okay if you want to remain on H or L status and then continue traveling using your visas. Actually, with this administration, it's generally our advice that if you can maintain your H-1B status, we think it's always good to do that. And, to continue on in the H or L status. If that is not possible because maybe you need to change jobs and the employer is not willing to sponsor you for the visa, then certainly you can move forward and use the EAD and the AP. And for everyone else who is not in H or L status, for people that have entered the U.S. as a student or as an E2 investor or an O1 person of extraordinary ability, all of those individuals can only use the EAD and AP. If they're going to travel and use the AP, they can only use the advanced parole. They can't travel on their underlying visa anymore once the I-485 is filed.
Sure. I guess this was an $800,000 question, and the question is, which category is expected to retrogress the first? Is it the rural, is it the HUA, or is it the infrastructure category? I open the floor for both of you.
Well, this is tricky because neither Jen or I have a crystal ball.
Yes.
But if I were to guess, I think it will be rural. But again, it has more of a percentage allocated to it, 20%. And there is a sort of Band-Aid in the RIA where if the maximum amount of visas are not given out in a given year, it will move to the next year. So you're not necessarily losing them. So we don't know how long, but it has been very popular with India and China. And sometimes when something is popular, it becomes a victim of its own popularity.
Sure.
Jen, do you agree with me?
I think the answer to that is yes. And also the USCIS just announced that they're going to prioritize looking first at I-526E cases where the I-956F project pre-approval is already approved. So once the project application is approved, they turn to the I-526E petitions that are associated with that project. And they did say that they're going to first look at all of the I-526Es associated with the rural cases until the maximum number of visas available have been reached for the year. So that's signaling that they're going to try to prioritize approving as many I-526Es as they can with rural first, and then turning to TEAs. And so I think that will also likely cause rural to backlog first because they want those visas to be used every year, the 2,000. They don't want any visa waste. And they're really going to try and prioritize getting those approved so that people can move forward and have the I-485s approved or have the visas granted at the U.S. consulate abroad.
I want to throw one more thing out there, and that is that earlier this year, the Trump administration introduced the 75-country visa pause or ban. And it doesn't impact, the big EB-5 users, China, India, Vietnam, but it does impact a lot of other users. And so what does it mean? It means those people cannot be issued an immigrant visa. And those numbers are going sort of back into the pot and also can have an impact on when retrogression occurs or doesn't occur. Because again, if visa issuance isn't max, then it delays the retrogression.
Sure. Yeah, I think I couldn't agree more. An interesting question on staggered investment. So investor asks, am I required by the law to invest the entire $800,000 at once, or can I be in the process of investing while filing a I-526E petition?
Great question. And the answer is, the law says you can be in the process of investing. That's what the law says, even at the 829 stage. But this administration has really been focused on this issue. They don't like partial investments, and they have been issuing requests and sometimes straight denials where they see a partial investment, and by the time they get around to reviewing the case, the second or third investment is not completed. So for many clients, to keep this from happening to them, if they already have pending applications, we have been interfiling proof of the source of funds and the proof that the second or third or fourth investment is made. And in that case, they have been approving those cases.
Yeah. I think I would probably also want to share something on this topic specifically, is that the choice of making a staggered investments, I think, especially when it comes to our consultations with investors, we always tell them that is a decision that they need to take in consultation with their immigration attorney. When a regional center chips in, is essentially understanding our commitments to the project and its funding timelines. And we would generally prefer a funding gap of, or a staggered investments of max 3 to 6 months, not more than that. Just ensuring that, if by that time, obviously the investor fully funds. And I guess as immigration attorneys, you would also maintain the same fact that investors, when looking at staggered investment, should only use it as an option if really required, not as an option of convenience or to make a little more money, because that's not going to help with their I-526E petition.
I think that's correct. And I will tell you, in the last 2 months, I have filed applications, and literally a week and a half to 2 weeks later, I'm getting an RFE on those cases. So I think your advice is good and it's cautious, but I think the government is using AI to scan petitions and setting just upon receipt immediate RFEs. And so the pace that they're changing direction in is lightning speed. And we're just telling clients, this is a risk. You can assume the risk, or, the most conservative advice is to invest fully at the time of filing.
Absolutely. In the interest of the audience, we'd like to clarify that a visa bulletin does not give you exact timelines in terms of future predictions. It does not and cannot refer to a total backlog or size, and it does not guarantee outcomes. It is a fact in present and a reflection of what could possibly happen in the future. But as Jennifer and as Kate mentioned, none of us, unfortunately, have a crystal ball. I wish we could predict USCIS visa bulletins and help our investors achieve the American dream as soon as possible, but it takes its due course, and we all are at the mercy of the USCIS from that perspective. Jennifer, this one's for you. Any common mistakes that you've noticed when it comes to investors when they're looking at the visa bulletin?
I think just understanding your priority date, understanding where you are in terms of the visa set aside, whether you are, one of the set aside categories. And I think exactly what you were just saying, treating it as, okay, this is setting my wait time at, only 6 months wait to a green card, or 1 year, wait to a green card. If we do see a retrogression of visa numbers in the visa bulletin for our set-aside categories, for our post-RIA investors, the date that appears doesn't mean that you're going to wait exactly that amount of time. You have to really monitor each month what's happening, keep in contact with your lawyer's office to determine what the impact is on your case, and really just keep, looking and monitoring. And I think, that brings us to a really important point that, we sort of keep touching upon, Kate and I at least, is to, if you're not already doing EB-5, we have this super important deadline coming up on September 30th, 2026. And the, RIA says that if you file your I-526E by September 30th, 2026, then even if our Congress does not extend EB-5 further, because EB-5 is currently going to sunset again on September 30th, 2027. So if you file your I-526E 1 year before that final sunset date, even if our Congress does not extend in the future again beyond 2027, you can continue in your immigration process. So right now we're in the middle of April. We have until the end of September to file. So we're rounding a time of, we just have like 4.5 months left. And, Kate was just talking about partial investments and, can I just send in some very low amount of money and then get myself organized and figure out where the rest of my money is going to come from? The answer is no. I don't think you can do that, right? USCIS has clearly said that you have to outline and provide details about your full investment and source of funds for those investments in your I-526E, even where you're going to do a partial investment. So I think now is the time, investors see Chart A of the Visa Bulletin for our set-aside categories still says current everywhere. You're eligible in the rural, the high unemployment, and the infrastructure categories. You're eligible to file not just the I-526E, but also the I-485 if you are here in the U.S., regardless of your country of birth. And so if you're able to file early, start filing now. We don't know how the Visa Bulletin will move as we get closer to September 30th, because we're seeing a lot of people file as we approach this deadline. And, again, it takes a lot of planning to make it to the point that you're ready to file the I-526E. So you have to work with your project and your lawyer. So start now.
Yeah, I think that's a very valid point, and this is pretty much what we were going to talk about before we wrap up. I think it's imperative for anyone who's looking at the EB-5 visa program to obviously be aware of the 30th September 2026 deadline, but I guess most importantly also work backwards, right? Because I think whenever an EB-5 investor starts looking at a project, they work backwards, and for them to work backwards, it all starts about job creation, I-956F, and all of that stuff, but I guess the road is not taken until you hire an immigration attorney. And I think, Kate, if you could, share a little bit of insights on why is it important for those who are planning to meet this 30th September deadline to hire an immigration attorney as soon as possible, because it genuinely takes some time to work on your source of funds petition.
Yeah, I mean, look, this is a process. Even if you're in the U.S., even if you have U.S. source income, you have to go back in time. You have to give 7 years of tax returns. You have to give bank statements showing, money coming into your account, money moving between accounts, money being invested. You have to show the source of investment. Rarely does it come solely from income. It comes partially from income. It comes from a sale of real estate, a sale of stock. It comes from an investment made. There is a combination of sources. And the sooner we file, the sooner you lock in your priority date. We've been doing this, Jen and I, for 20 years. And every time there's a big rush, there's a big deadline, it is going to be crazy. People are going to be filing left and right because the price is going to go up, because the rules are going to change. And the sooner you lock in your priority date, the better it is, because as we get to the end, there's just going to be a lot more applications coming in. And if retrogression develops, even 1 week between filing makes a big difference in when you will get your green card. Plus, USCIS can make errors. They have contractors working in their mailroom. Sometimes applications get lost. They file and receive thousands of applications every day. So you want to file as early as possible. If there's a problem, you can resend it. You want to secure your priority date. And, if you want to file concurrently, you also have to think about, I'm in the US, I need to get my medicals done, I need to get my birth certificate, my marriage certificate, any divorce certificates. If you've lived abroad, that takes time too. So you have to work with your attorney to get a list of everything that you need in order to file for you and your family members.
Yeah, I think we at US Immigration Fund always maintain the fact that an immigration attorney such as you guys are typically the backbone of this entire process, and it is absolutely important for an investor to first consult an immigration attorney, hire one, try and get their source of funds approved, because until and unless they do get a green light from an immigration law firm or an attorney, a regional center is incapable of receiving any of those funds. So, as a prospective investor, you might love a project that you might want to invest in, but you will definitely not be able to make that call until unless you get a green light from your immigration attorney. We have just two final questions coming in. One is, what exactly does the word grandfathering mean? If you could, just shed a little more light on that. This is open. Jennifer, Kate, anyone?
Jen,
Sure. Sorry, I was muted. So what that means is if you file your I-526E petition before September 30th, 2026, then you can continue in the process even if Congress doesn't extend EB-5 further. So EB-5 is a multi-step process, right? So number one, you're filing the I-526E petition. And right now, we just discussed, if you're here in the United States, you can also file the I-485 along with it. So once the EB-5 petition, the I-526E, is approved by USCIS, then USCIS will turn to the I-485 application in order to give you the 2-year green card. And then at the end of the 2-year green card, you need to file the form I-829 to receive the permanent green card. So USCIS is saying that if you file your case by September 30th, 2026, you can still file an I-485 later. You can still have your I-485 approved later, even if Congress does not extend the EB-5 program past 2027. So I'll give you an example. If I file on September 15th, 2026, my I-526E petition, and I also file my I-485, but then we have a slight retrogression of EB-5, okay? So my I-526E can still be approved. That timeline is not impacted. But I'm not able to get my I-485 approved until the year 2028, let's say.
Yeah.
But Congress does not extend EB-5 past September 30th, 2027. It doesn't matter that my I-485 is not yet approved. USCIS can still issue a visa number to me and then approve my I-485 later when the visa number becomes available to me. If I filed on October 15th of 2026, just 30 days later, the grandfathering does not benefit me. And so let's say, again, I'm subject to some visa backlog and my I-485 remains pending after September 30th, 2027. Then if Congress takes no action, does not extend EB-5 again in the future, they could deny my I-485, saying that there's no more program and no visa available to me. So it's very important to be mindful of that date. And also importantly, once you file your I-526E, you're locked in at the investment amount and at the requirements at the time you filed the I-526E. And we know that in January of 2027, the EB-5 Reform Act requires our USCIS to actually increase the minimum investment amount for EB-5 due to the inflation that's happened since 2022. So, for example, anyone who doesn't meet the grandfathering deadline and thereafter files an I-526C, let's say in February of 2027, your investment amount for a rural project or a high unemployment project or an infrastructure might be closer to 900,000 based on the inflation that happened. And you also are still risking that, Congress will continue to extend EB-5. So, of course, everyone here is hopeful that we will have another extension of EB-5. We have since 1992. So it would be, it would be great to have this keep going, and we believe it will. But the requirements may change, and it might get more expensive. So, again, the locking in and the grandfathering is really important.
Absolutely. Before we end on a very lighter note, Kate, there's a question which says, is EB-5 all about paper applications, or can I also e-file? On a lighter note.
No, unfortunately, USCIS hasn't moved to e-filing for all application types. So we're still filing paper EB-5s, but we are doing better than we were pre-RIA. We don't have to submit all of the project documents because they're relying on the 956F approvals. We just have to submit the source of funds and then the concurrent filing if you're in the US.
Absolutely. So I think the common consensus is that right now is the time, and that time is before 30th September 2026. There is obviously an overwhelming list of questions that keep coming in. I guess we all did a good job. I would request everyone, that our contact details are on the presentation. Please do feel free to reach out to us via an email or directly, and we would be more than happy to answer your questions. I hope that this webinar was helpful for all the attendees and for everyone else who probably sees us via an Instagram reel or a YouTube video, to try and get to know a little bit about how to understand the May 2026 visa bulletin like an immigration lawyer and an expert. Before I conclude, my sincere thank you to Jennifer and Kate. Thank you so much for taking out the time. Sincerely appreciate you guys, and I hope that you had a good time, and we'll definitely look forward to many more such webinars in the future.
Thank you for having us.
Take care, everyone. We'll see you shortly. Bye-bye. Thank you.